Good morning. Happy Saturday. I got a pretty good question going on here from Tech, and it got me thinking that maybe I could use this opportunity to teach folks how I do legal research. I'm not saying that I'm the best at it in the world, but they do teach you how to do legal research your first year of law school because it's important. It's one of the most necessary skills an attorney has. So let's set up the backdrop. Blind Justice accused his district judge, Judge Freeman, of committing criminal acts. And one of the criminal acts that he accused the judge of is violating North Carolina General Statute 14-230, willfully failing to discharge duties. And I made the definitive statement in this video on 10/31 of 2020 that 14-230 does not apply to judges. So how did I come to that conclusion? Well, to start off with, you got to do legal research. And so when he said that he believed that the judge violated 14-230, the very first thing I did is I read the statute so that I know what I should be looking for. And then I went to Google Scholar because I don't have a LexisNexis subscription and I'm not going to go to the law library to look this up. But I went to Google Scholar and I started researching the various terms to try to figure out how courts have defined this. Because in order of importance, the way you do legal research is first you look at the case law. You see how courts have defined terms. You see how courts have interpreted statutes. You see how courts have interpreted the terms in statutes. What actually is willful misconduct for the purpose of the statute? Second thing you look at is Constitution, because constitutions take priority over laws. And then the third thing you look at is the actual law itself. So you can see that some of the search terms that I've used, and the problem I ran into is I didn't find anything showing that 14-230 applies to judges. Nothing in here showed that it applied to judges. So that started my noggin jogging. But there was this one, State v. Greer, which said that it applies to magistrates. And so, again, noggin jogging. There's section 17, removal of judges, magistrates, and clerks. Well, so first thing is I went back to the statute and I reread the statute more closely, and I saw that it does in fact list magistrates as the only judicial officer that is listed specifically by title is magistrate. Now, I did see, as you could see from the search terms, I did see that there was state institutions and officers. But it seems weird to me, and it activated my almonds, that magistrate would be listed and judge would not, because judges are, of course, more important than magistrates. So anyway, back to the Constitution of North Carolina, Article 4, Section 17. This right here, again, got my noggin jogging. Additional method of removal of judges. So there is, in Article 4, trial of impeachments, that will get you judgment upon conviction shall not extend beyond removal from and disqualification to hold office in the state. So that is the possibility one. And it does, in fact, say that in Section 1, or in subsection 1 of Section 17, that impeachment still works. But then it says the General Assembly shall prescribe a procedure in addition to impeachment and address set forth in this section for the removal of a judge, justice, or judge for misconduct in office, etc. So they shall do it. They shall prescribe a procedure. Well, that language, you got to pay attention to words. I mean, people accuse me of lawyering all the time, but the reason why I am effective as an attorney is because I pay attention to words. Words have meaning. Shall prescribe. That means they are going to do this. They are going to do this. It doesn't say the General Assembly prescribed, past tense, a procedure. It says they shall do it. So when did this section take place? Or when was it enacted? It was enacted in 1971. It authorized the General Assembly to prescribe procedures for censure and removal of state justices and judges. So prior to 1971, the only method of removal was by impeachment. Well, that's a big thing. So the only method of removal is by impeachment. Now you're saying, why does removal matter? Well, removal matters because the punishment for violating 14-230 includes removal from the office. If you violate 14-230 and you're convicted of it, you are removed from office. But the only way of doing that prior to 1971 was by impeachment. So this is a criminal law, but this is the only way to do it. So these two are in conflict. And if a statute is in conflict with a constitutional provision, the constitutional provision wins. And the statute has to be interpreted. It must be interpreted in a way, if it can be, that will make it to not be in violation or contradictory to the constitutional provision. So prior to 1971, this existed. So this was initially codified as a law in 1901. So when this was made into a law, when 14-230 became a law, it had to be interpreted in such a way as to not be in conflict with Article 4, Section 4, and Article 4, Section 17. It had to be interpreted in such a way that it didn't conflict with those, which means it had to be interpreted as not applying to judges. It had to be. Now, you'll notice that when we were talking about this one, it says the General Assembly shall prescribe a procedure, right? So after 1971, maybe they did something to make 14-230 apply. And you'll see that they started, so 1943 is the last one pre-71. So post-71, they have amended it 1, 2, 3, 4, 5 times. They've amended 14-230 5 times. These are important. And it's important to look at these. You don't always have to look at them, but if you're wondering how a statute has come to be a statute, this is what you do. You look at these things. So the first one is 1973, Chapter 108, Section 5. 1973, Chapter 108, Section 5, General Statute 14-230 is amended by deleting from line 2, Justice of the Peace, and inserting in lieu thereof magistrate by deleting from lines 2 and 3, recorder, prosecuting attorney of any recorder's court, and by deleting from line 4, constable. So it appears that they eliminated Justice of the Peace, maybe statewide, probably statewide, and they rolled up the office of the Justice of the Peace into the office of magistrate, or maybe they just did a name change. I don't really know. Doesn't really matter. But what this does show is that after 1971, the General Assembly did not make 14-230 apply to judges. Obviously, they could have. They could have added in and also add judge, but they didn't do it. So as far as up to 1973, it still doesn't affect judges. The next one is 93, Chapter 539, Section 142, 93, 539, and then Section 172. Aha. Whoa. There we go. There you go. Section 142. So what they've done, you can see that they've underlined things here. These just show the changes. So an underline means that they've inserted class 1 in front of misdemeanor, and they inserted offense period. And then they deleted, strike through means deleted, they deleted offense and shall also be fined or imprisoned in the discretion of the court. So they did not add judge or justice anywhere in here. So as far as 1993 is concerned, they did not change it to make it apply to judges or justices. The next one is going to be 1994, the extra session, Chapter 24, Section 14C. 1994, extra session, Chapter 24, section 14C. It changes section 1359 of chapter 539 of the 1993 session laws to strike out January 1st, 1995 and make it effective October 1st, 1994. And that's what I was looking at down here. This is 1359. They struck out January 1st, 1995 and made it come into effect in 1994. The next section that they changed, so again, it doesn't apply to judges. Still does not apply to judges. Next is 2009-107. There's 2009-107. They've added school board member. So that's the only addition they make. It still doesn't affect judges. The next one is 2015-75, section 2, 2015-75. And it's section 2. They've added subsection A. If you notice back here, there was no subsections. They've added subsection A, and they've added subsection B, and then the text for subsection B deals with magistrates. Again, it does not apply to judges. So what did they change? Well, this right here is what they changed. They created a commission. And you can see this came into effect in 1971, conveniently at the same time the General Assembly became authorized to prescribe a procedure for the censure and removal of state judges. That's when this became effective. And upon recommendation of the commission, so this isn't in criminal court. The Supreme Court has original jurisdiction on this stuff. The Supreme Court of North Carolina, I should say. Upon recommendation of the commission, the Supreme Court may issue a public reprimand, censure, suspend, or remove any judge for willful misconduct in office, blah, blah, blah. So this is how a judge can be removed from office, etc. So I hope that makes sense. You have to look at all the words. You can't just say or official of any of state institutions and therefore it applies. You actually have to look at everything. Go through the beginning, look at each word, make sure you understand each word, and you'll be able to get to the same conclusion that I did, that 14-230 does not apply to judges. I hope you found that helpful. I hope you learned how to do a little bit of research and the kind of thought processes that an attorney would go through when doing legal research, and have a great day.